Good morning. You can always tell who the true hardcore FedSoc members are bright and early on Saturday morning of the convention. I hope this new day finds you very well. Welcome to the third and final session of the 2025 NLC. I'm Nate Kazmarek, Vice President for Practice Groups and Networks. It's hard to believe that we're already at the last day of what has been an exceptional gathering of ideas, energy, and fellowship. Last night's receptions and conversations carried forward the same intellectual spirit and good humor that make this convention the highlight of the year. And of course, it wouldn't be the same without all of you, our dedicated and wonderful members. Thank you for joining us. Show of hands, who is here for their first time at the convention? Wow, amazing. Thank you for being here. Who's been here 5 years? 10? 25? That's amazing. And last call, 40 years or more? Wow, let's give everyone a round of applause. That's excellent. Thank you for coming. Today's programs promise to be no less engaging than the first 2 days. We'll hear from leading experts on some of the most pressing questions in education, health, labor, parental rights, and property rights. And at lunch, we'll look forward to our 17th annual Rosencrantz debate featuring Professor Mary Ann Case and Kristen Wagner. Before we turn to today's program, I want to take a moment to note two new network initiatives launched by the Society this year, both of which reflect our continuing effort to bring our mission to new corners of the legal and civic community. The first is the Armed Services Legal Network, which we launched on September 11th at Mount Vernon. Through events, publications, and member engagement, this network will bring together service members, veterans, reservists, defense lawyers, policymakers, and scholars for rigorous, respectful dialogue on the most pressing issues facing America's military and our national defense. We're excited to see that this FedSoc military community, excited to see what this FedSoc military community can accomplish, and we look forward to your input and engagement to make it a success. The second network I wanted to mention this morning is the Family and Parental Rights Network, which we officially launched yesterday at a special luncheon here at the convention. This network will engage lawyers, scholars, and policymakers on vital legal questions surrounding parental rights, family autonomy, education, and the interplay between family life and government authority. Its goal is to ensure that these foundational issues receive the same rigorous and thoughtful attention that has long characterized the Society's work in many other areas. If you'd like to learn more about either network, please stop me today during the conference to chat or send an email and we can connect in the coming weeks. Together, these two networks exemplify what makes the Federalist Society unique, a community of legal professionals expanding the conversations while staying grounded in first principles. Before I turn things over, don't forget that if you need CLE today, you have to scan the QR code on the back of your program to sign in and to sign out. To open our morning session and to introduce our third plenary panel on AI, it's my pleasure to welcome Gabriel Powell, President of the Notre Dame Law School Federalist Society Student Chapter. Gabriel has been one of our exceptional student leaders. Please join me in welcoming him.
Good morning, everyone. As Nate said, my name is Gabriel Powell, and it is my honor and privilege to introduce our moderator for this panel on AI for the Law and Law for AI, Chief Judge Jennifer Walker Elrod. She was nominated to the Fifth Circuit in 2007, and she served as a circuit judge in the court until assuming the role of Chief Judge in October 2024. Prior to serving as a circuit judge, Chief Judge Elrod was appointed and then twice elected judge of the 190th District Court of Harris County, Texas, where she spent over 5 years presiding over more than 200 jury and non-jury trials. Chief Judge Elrod graduated cum laude from Harvard Law School, where she was an active member of the Harvard Federalist Society, an Ames Moot Court finalist, and a senior editor of the Harvard Journal of Law and Public Policy. She clerked for the Honorable Sim Lake in the Southern District of Texas. Before serving as a judge, Chief Judge Elrod worked in private practice, focusing on civil litigation, antitrust, and employment matters. Chief Judge Elrod is actively engaged in the academic and legal communities. She currently serves on the board of directors and as the jurist in residence at the South Texas College of Law, where she teaches civil procedure and First Amendment law. She is also a member of the American Law Institute and of the Board of Advisors for the Harvard Journal of Law and Public Policy. She is a frequent speaker on the topics of trial and appellate procedure, ethics, employment law, and constitutional law. And Chief Judge Elrod also serves on the board of the Garland R. Walker Inn of Court and co-produces an annual musical CLE for which her pupillage group has won multiple national awards. Chief Judge Elrod has also been published on several of these topics, and most relevant here, her article, Trial by Siri, AI Comes to the Courtroom. Please join me in welcoming Chief Judge Elrod.
Thank you so much, Gabriel, for the very overly generous introduction, which has taken up half of our time because we are only going to have an hour, so we're going to have to book it. But I would be remiss if I did not take the time to introduce this very distinguished panel. Ryan Bangert serves as Senior Vice President for Strategic Initiatives and Special Counsel to the President at Alliance Defending Freedom. He oversees ADF's government affairs and Blackstone fellowship teams. Before joining ADF, he served as the first Deputy Assistant Attorney General and Deputy for Legal Counsel in the Office of the Texas Attorney General, as Deputy for Civil Litigation for Missouri Attorney General Josh Hawley, and he was also a litigation partner at Baker Botts LLP. He earned his JD from SMU, and he clerked for the Honorable Patrick E. Higginbotham on the Fifth Circuit Court of Appeals. Ryan is brilliant and thoughtful, and it's a delight to be with him today. James Burnham is the founder and managing partner of King Street Legal PLLC. He recently returned to King Street Legal after serving for 6 months as the General Counsel for the Department of Government Efficiency. You know that by another name. DOGE. In that role, James designed the legal structure of DOGE, advised DOGE personnel on policy initiatives across the executive branch, and supervised dozens of DOGE-related lawsuits against the executive branch, many of which DOGE won in the United States Supreme Court. Before founding King Street Legal, he was a litigation partner at Jones Day Law Firm, a senior official in the Department of Justice's Civil Division and Office of the Attorney General, and a senior associate counsel to the President. He also clerked for Justice Neil Gorsuch on the Supreme Court and Judge Alex Kozinski on the U.S. Court of Appeals for the Ninth Circuit after graduating with high honors from the University of Chicago Law School. And he earned a bachelor's degree at the University of Texas at Austin. Do you see that we have Texas in common?
Exactly.
Yes.
We're going to be in Georgia today.
In addition to leading the firm, James is the president of Vallecito Capital LLC, a mission-driven litigation fund that ensures meritorious litigation does not falter due to lack of resources.
Thanks,
Welcome. Judge Kevin C. Newsom is a member of the United States Court of Appeals for the 11th Circuit. He sits in Birmingham, Alabama. And before his appointment to the bench, he was the head of the appellate practice group at Bradley Arent, and before that, the Solicitor General of Alabama. As a practicing lawyer, Judge Newsom argued 4 cases in the Supreme Court of the United States and nearly 40 more in the United States Courts of Appeals and state Supreme and appellate courts. He graduated summa cum laude from Samford and magna cum laude from Harvard, where he was an articles editor on the Harvard Law Review. He then clerked for Judge O'Scanlan of the United States Court of Appeals for the Ninth Circuit and Justice David Souter on the Supreme Court. He teaches at Harvard and Yale. He publishes, and he is the only circuit judge I know who admits in public that he uses AI to write his opinions. Welcome. And we're also very pleased to be joined by Michael Trinh, currently Associate General Counsel, Litigation and Discovery at OpenAI, based in the Bay Area. He was formerly head of litigation advance at Google, where he led a team handling a broad portfolio of appellate and amici work, litigation policy and strategy, and affirmative litigation against abusive conduct of Google products. The litigation included lawsuits targeting online scammers preying on senior citizens and a coordinated legal cybersecurity campaign disrupting a Russian blockchain-enabled malware network that compromised millions of computers. What a lot. In prior roles over 15 years at Google, Mike managed a group defending a fast-growing docket of more than 100 patent litigation cases worldwide and served as product counsel at Google X for emerging moonshots. He's also guided experimental aviation projects. Previously, he was an associate at Orrick in San Francisco. He graduated from Georgetown Law Center and the University of North Carolina at Chapel Hill with a BS in computer science. He is all over this field, and I know we're going to learn a lot from him. And we're also mutual lovers of Star Trek, and so it's a pleasure to be with you. I'm glad you're living this dream, actually developing all this, since you love that stuff so much.
Let's get into it.
All right. And Tobi Young, one of the most amazing people I have ever known, is also on this panel. She is currently the General Counsel of Saronic Technologies, and she serves as the chair of the Nominating and Governance Committee on the Halliburton Board of Directors. She has worked in all three branches of the federal government, including positions at the Department of Justice, the White House, and the U.S. Supreme Court as a law clerk for Justice Gorsuch. She has also served as counsel to President George W. Bush. Tobi is a proud member of the Chickasaw Nation and was recently inducted into the Chickasaw Hall of Fame. And she is my friend, and I'm so glad she's here. AI did not write this introduction, or it would be shorter. I started speaking and writing about AI in 2019, and a lot has happened since then. ChatGPT launched in November 2022, and according to the AI hallucination case database maintained by Damien Charlatan, the first case of AI hallucination by a lawyer was in June 2023. Now the database has 133 such instances by lawyers in the United States. There are 340 instances if you include pro se litigants, and now, unfortunately, there are also some instances of judges in that database as well. We are about to see the first class of lawyers enter our profession who has had access to ChatGPT during their 1L legal writing class. Rumor has it that they're really good with the technology, but may not yet be able to not use the technology, so we'll have to wait to see that. In April, my husband, who moonlights as an instructor at Georgia Tech, and I gave a talk to a group of computer science and engineering majors at Baylor entitled How Not to Be Replaced by AI, something on everybody's mind. And we are having lots and lots of new litigation, lots of national security concerns, and this next frontier is really exciting and scary and awesome. With that, let's start on a fun note. What's the coolest thing you've seen AI do, legal related or not? And if anyone builds it, does everyone die? And do we need to do anything about that? Who wants to take that? James.
Sure. Okay. Well, on the first, look, my answer on the first one's not going to be that exciting. I mean, look, it's just a really useful tool that replaces. I mean, I'm old, right? So I did not grow up with AI, obviously, but you can use it for all kinds of very practical things. Like, I did a Supreme Court talk at Heritage, and there were a couple of cases I didn't know what those cases were, and I wasn't going to go like read the briefs, so I went to Grok. I'm a Doge Grok, you know, I'm a Grok guy, and it was great. I mean, it like summarizes all the briefs, and when you give it a nice discrete question like that, I mean, I don't know, I haven't tried it for like kind of harder legal questions, but it can do a very, very good job of summarizing like a discrete data set, and so it was fantastic. It like cut my prep time down by a lot. I didn't have to go rummaging around SCOTUS blog, looking for the cert petition, all this other nonsense, and it was super helpful. So if you're just working on something like that, if you're doing an op-ed or you're doing any kind of writing, like it can be a really, really good supplemental research tool that is just 1,000 times better than Google or anything that we had available for a few years ago. The more interesting question is whether it'll kill everyone. I actually think that's obviously like a very important question, and I think that's why. Well, but I think that's like actually the big differentiator among the different AI businesses is it is actually quite important that if we, it could be that the hype is wrong and that really all that we're doing is building like a really, really good like language predicting device that is very, very good at predicting what a human would say in response to a question, and that it kind of caps out there. That's totally possible. Although that even would be quite extraordinary, particularly if you combine it with spatial AI and moving around. I mean, one of the reasons why I think Elon's constellation of companies is so interesting is because he has humanoid robots, at Tesla, and then he has the AI at XAI. And if you combine those, you actually literally have C-3PO like walking around your house doing things, which is, I think that's pretty cool. But whatever, we can talk about whether it's cool.
It could be annoying.
It could be annoying, but you could just tell him to stop talking. He'll do whatever you say. But on the kill us all point, I think it's really important who's designing the model and how it's being done. I mean, to the extent humans understand how the models work, which I think is itself a debatable question, you really want the humans that build the one that wins to be humans who care about, things like truth and honesty and like Western civilization, humanity. Like these are pretty fundamental values that you want to have inculcated into the tech from the beginning. And so that's like a reason why I think you should differentiate among US companies, but it's also a reason why it is so important to not get in the way of the US companies when we're fighting against the Chinese companies, which I guarantee do not care about any of those things. And so, it's kind of like a complicated matrix, but the Chinese are going to do it regardless. And so I don't think we actually have much of a choice about whether to lean in hard. And then we just have to sort of hope and support that the right players win here and we end up with something that does not, as Judge Elrod said, kill us all.
Mike, do you have any thoughts on this?
Yeah. Hey, everyone. Good morning. Thanks for having me here. It's my first time, so I'm delighted to be up here. In terms of the use cases, the one example I'll highlight, when I send out requests to outside counsel, you write off a request and I'm going to wait a while before I get answers. So I ask ChatGPT to check what I'm missing, add a few questions, and that's pretty normal, that's pretty routine, but that's the last thing that kind of reads through what I wrote. I've recently learned that some of my outside counsel have started, I'll ask a bunch of things and they're trying to make sure they cover everything. The last thing they do after an associate writes something up is they run it back through ChatGPT to check. And so I'm like, wait a minute, I've got ChatGPT actually asking for something that gets output from someone else's ChatGPT. So,
It's like
I see some opportunities for efficiencies, but interesting use cases there. Now, as for the second question, as for whether it kills us, I'll say OpenAI, we've taken this approach of iterative deployment. There should be no surprises with AI or, frankly, any technology out there that is in broad use. And so, one of the interesting things about ChatGPT that people don't realize, it was indeed launched 3 years ago this month. The underlying capabilities that it used had been out in API form, had been available to developers, but just not in the chat form. For over 6 months beforehand, right? It's just that additive kind of, different interface, the ability to chat natively with that technology that allowed people that gave birth to that kind of explosive growth. And we've taken this approach of just incrementally trying to add new capabilities so people can actually see it, appreciate it, and kind of, see what it can do and can't do, and take this and, hopefully beget thoughtful conversations about, okay, how do we put safeguards in to kind of prevent harms, be it, from the mass extinction kind of catastrophic stuff to the more to closer in stuff. And so the idea is, putting out capabilities out there so that it's not just purely science fiction or something that's in, a paper. It's something that you can actually see and kind of, frankly, kick the tires and get a better sense. And so that approach hopefully kind of turns it into, okay, is it going to kill us, to how do we ensure that it doesn't, and how do we reassure ourselves that it doesn't?
Okay. Tobi or anyone else want to respond on something cool you've seen, or whether we need to be able to turn it off if it develops a fierce case of self-preservation?
Well, I will go to the first question Evan has used Grok to make our 9-year-old into the best soccer player in the world. And it's really fun to do on your parents. They get very confused when you take a picture of them and all of a sudden they're dancing. So it's a great way to bridge divides between generations and show them what's happening. And also, I work at a company where we build autonomous ships. So AI is the cornerstone behind what we're doing. I mean, we have ships that will talk to one another independently. They pick a leader between each other and they go off and execute a mission. I mean, it's just incredible, the leaps and bounds that we have been able to accomplish with this technology in such a short amount of time. And I think back to, at Halliburton, I was talking to a mathematician who said it took him 10 years to solve a specific equation to help them be the leader in a technology issue. And just that resilience and having the best people who will go and do the work necessary. It doesn't take 10 years to solve math equations anymore. It's like this. So how do you differentiate? And I think, I don't worry about is it going to kill us, because it's a new thing every day that's going to kill us. It's going to be what it's going to be. But it's the people that are taking the technology, just like they've been talking about, James and Mike, of how do you use this responsibly and making sure it's the West that wins and defining how it's used. And I think we'll get into this in national security, but a lot of countries really don't care where their AI is built and coming from. They're not thinking through what the CCP has done to wash through data. They're going to buy what they think is the best and is out there. And so we have to be the best. We can't let regulation kind of get in the way to making sure we're defining these terms and how they're used.
Okay. Well, let's narrow on the legal field for a minute here, and let me ask you, Ryan, are we going to have a revolutionized legal profession with our work very automated? And is that a good thing for lawyers or a bad thing? Are we going to have big law firms anymore? What's going to happen? I've seen some cool things. I know you can ask it what questions I'm going to ask at oral argument, and it'll tell you a big proportion of questions I'm going to ask at oral argument. But I know that really a lot of value is in that maybe we don't need e-discovery as much in the way that it's done. So help.
Yeah, no, that's a fantastic question. And going back to your first question, I don't think that AI itself is autonomously going to eradicate humanity. But just in case, we all pledge fealty to the basilisk right now. For those who don't know what I'm talking about, that's a deep cut on AI. But in terms of the legal profession itself, I don't think that it's going to eliminate the need for lawyers, but I think it's going to revolutionize how we practice law. There are a number of different studies that have been performed on how lawyers are using AI in the profession right now, and e-discovery is definitely number one on that list. I mean, certainly when I entered the legal profession back in 2005, there was this thing called document review, which many of you remember, where you're just clicking through documents and reviewing them by using your eyeballs, and that's really a thing of the past now. That would in fact probably be unethical under the rules of disciplinary procedure because you're not using technology appropriately. But it goes far beyond that. I mean, document summarization we've talked about. I mean, many of us remember summarizing deposition transcripts. That was something that was a very common associate task. That's out the window. You really should never be doing that anymore if you're an associate. Contract and transactional document review. There are a number of applications that can actually perform very in-depth and sophisticated transactional review of documents. Drafting first drafts of discovery, interrogatories, requests for documents, preparing deposition questions. These are all good uses of AI, but also some of the edge cases right now, using AI to test the strength of your case, actually having AI conduct really an instantaneous mock review or mock of your arguments in a trial setting. These are all things that can be used, that AI is being used for right now. So some of the higher order analysis is definitely on the table. One thing I don't think AI can do, however, is replace lawyers. And there's an interesting study that was recently performed by the Stanford Artificial Intelligence Institute. They have an index that comes out every year, and I'm going to read from their report. This is kind of the edge of where AI is at. It says, complex reasoning remains a challenge for AI. The models excel at tasks like the mathematics Olympiad, but struggle with complex reasoning benchmarks. They often fail to reliably solve logical tasks, even when correct solutions exist, limiting their effectiveness in high-stakes settings where precision is critical. So the higher-order reasoning tasks, they're not yet reaching into those yet. So that's a place where lawyers can still deliver real value. And the one thing I am concerned about, however, is training young lawyers. There's been a number of studies. The MIT Media Lab recently conducted a study that shows that if you, it was an interesting study because it had two different groups of students they were drafting essays. One drafted them from their mind, no sort of aids. The other drafted using AI. And when they switched the tasks, they found that those who initially drafted using only their memory performed better using AI. And what they found was there is a significant cognitive offloading that takes place if you rely entirely on AI to perform a task. And so basically your mind is a muscle. And if you're not using it, it atrophies. And there's a significant atrophy that takes place if you cognitively offload those higher order reasoning tasks entirely to AI in the first place.
So should we not have AI training in the first year of law school and wait to the second or third year as a result?
That's a fantastic question. I think the jury's still out on how to integrate AI into legal training right now. I think what we can say with confidence, though, is we need to encourage young lawyers and law students not to be over-reliant on AI to perform those sort of mental, cognitive tasks that they need to learn early on in their careers. So it can certainly be an aid and a help, but it cannot replace the reasoning functions that lawyers need to develop early in their career to function at a high level. So the cognitive offloading problem, it's not just in law, it's in every domain. But we need to be cautious and cognizant of the fact that over-reliance on AI, just like accountants when they were using calculators early on, lost their ability to do basic computational tasks. Lawyers could lose their ability to do basic reasoning tasks at the low levels of the practice if they cognitively offload those tasks to AI early in their career.
Well, Judge Newsom, do you think AI is going to change judging, and how is it already changing judging?
So I guess I would say, and I was joking with Judge Elrod before the panel began, the irony of the fact that I have become the face of AI in the judiciary couldn't be any higher. Because like here I am with my hard copy, sort of Redwell full of pieces of paper. I think my sole sort of qualification for being on this panel is that I just had the foolishness or the chutzpah, one or the other, to say the thing that other people were thinking but not saying. It's sort of like the genius of Seinfeld humor is that it articulates what other people, what is in their mind, but that they haven't either said out loud or put on a piece of paper. So we can talk about sort of how I got into this, but I guess now as a judge, largely as a consumer of legal research and writing, the first time I really ever thought much about this was maybe 3 or 4 years ago. I was at an 11th Circuit Judicial Conference. There was sort of a legal writing expert who was there, who was giving a talk, and he was saying, he said sort of offhandedly, this was at the beginning of sort of lawyers getting busted, so to speak, for using AI in their pleadings. There were a couple of lawyers, I think in New York at the time, who had been sanctioned by a judge for using AI in their pleadings. And there seemed to be this assumption that was sort of a horrible thing for lawyers to do. And I remember thinking at the time and sort of sheepishly raising my hand and just saying, look, and I think Judge Elrod would back me up on this, the quality of the advocacy that we get, written and oral, but especially written advocacy, even in the United States Courts of Appeals, is, let's just say, spotty. And are we sure that it, on balance, would be worse if lawyers were permitted to use AI to help draft their pleadings? Are we sure that's a bad thing? I think instinctively judges tend to think that's a bad thing, but are we sure that that would be a net negative as consumers of legal research and writing especially? And I guess I'm just not sure about that. With the appropriate disclosures, look, when I get a brief written by a real live flesh and blood human being, there's a risk that lawyer has hallucinated intentionally to potentially to outright mislead the court, I hope not, but at the very least to sort of slant the law in his or her favor. So we've got to go check those citations anyway. And so I guess I just want to sort of pump the brakes a little bit on this instinctive notion that it's sort of inherently a horrible thing for lawyers to be using artificial intelligence to help them draft their pleadings. I do think courts should know, but with the appropriate disclosure, I'm not really sure it worries me too much. And then from my perspective, sort of when I said the thing, it was in a case involving an insurance contract, the most sort of prosaic kind of case you can imagine. It was not a sexy First Amendment case or something. It was about an insurance contract that provided coverage for landscaping services. And the question at issue, in essence, was whether the installation of an in-ground trampoline constituted landscaping. And so, as Judge Elrod knows, and as most in the audience know, when courts are put to a question like that, you're looking for the ordinary understanding of the terms on the page. How would the ordinary reader of these terms understand what would the ordinary reader understand them to apply to? And so we did what good textualist judges do. We looked at the dictionaries, and the dictionaries seemed sort of inconclusive, frankly, about landscaping. Is landscaping necessarily something that is natural? Well, maybe, but you have accent lights in your yard on trees or something, on your crepe myrtles. Is that landscaping? Maybe. To the ordinary hearer? Maybe. Is it necessarily something that's aesthetic? Well, maybe. But like I said in the opinion, I've regraded a yard. When we lived in an old house over here in Alexandria, we were getting a little water in the basement, so Kevin had to go out and regrade the yard so that the yard sloped away from the house to keep the water out. I kind of thought I was landscaping, but it wasn't particularly, I wasn't beautifying the yard. In any event, so, as I was telling Mike before the panel began, serendipitously, I had working for me that year a fella who was a joint JD PhD from Stanford, and his PhD was in CS, computer science and machine learning. And so I wandered into his office and I said, what do you think ChatGPT would have to say about this? And he basically said, Judge, do you really want to go down this road? And I said, yeah, like with your help, I'm really curious about how that technology, and we can unpack this, but how that technology might help judges discern the ordinary understanding of words on a page. And so we did it. And frankly, in retrospect, I'm not quite sure I did the prompting exactly right. I'm sure that there are ways to improve upon what I did. But so we just queried ChatGPT and then Claude and then Gemini for the ordinary understanding of the term landscaping. And I got to tell you, I think it was pretty informative. And we can talk about the pros and cons of this from the judicial perspective. But one of the pros, I think, frankly, is the indiscriminateness of the search, so to speak. When you're looking at a dictionary, in some respects, that there are some dictionaries that are descriptive, some dictionaries that are prescriptive. You're not always sure which kind of dictionary you're looking at. And in some sense, that's a curated version. Some nameless, faceless boards, sort of curated version of what that term means. And I think in some respects, the beauty of the AI models, the LLMs, is that their search, their sort of understanding, so to speak, is indiscriminate. It goes out and it gets the smart stuff and the dumb stuff. And for better or worse, the dumb stuff is part of the ordinary understanding of language. We might not like that. We might sort of prefer the elite understanding of language, but we judges purport to be seeking to discern the ordinary understanding of language. And that ordinariness is going to have to scoop up, from the sublime to the ridiculous.
So does that mean we're going to be willing to say that insurance contracts mean what people on Reddit say they mean?
So I guess what I would say is, if you're seeking to understand what landscaping means, both sort of a PhD dissertation about the meaning of the term landscaping and the Reddit thread that happens to, sort of mention landscaping, I think both of those things are part of the ordinary understanding of that term, for better or worse, yes.
Okay. Well, Mike or Tobi, would you want to talk about how AI has changed the role of in-house counsel? We've heard a little bit how it affects judges, how it affects law firms.
So I think, I'll just say generally on this conversation, I've learned a lot going into a firm that's technology-based and how behind our profession is in accepting what is happening and where other knowledge-based professions already are. No software engineer is worried about their cognitive abilities to go away by implementing AI and using it to code and to solve big problems. They're doing it. I don't think we have a choice about how you use AI with law students because they're doing it. And so we have to really get ahead and be part of this and figure out, as a profession, as lawyers, how do we use this and make sure we're a part of this discussion? We're obviously a little, risk averse to begin with. We're the lawyers. We're not the ones creating these companies. But, I was having this conversation with our chief technologist and, about a lot of the knowledge-based jobs just go away because it's they're getting better and better and better. And I said, yes, but you'll need lawyers. You'll need someone in HR to do the nuance work, to make these decisions when you have all of the data. You still have that exception that you need the lawyer to come in and help you with. And he patted me on the back and he said, yeah, you can tell yourself that. And so I will just say from the business point of view, they don't see us as, they used to see us as a necessary kind of person in the room. I don't think they're seeing us as relevant as they used to, and we have to make sure that we become relevant and we're really adding something. And they talk about, the platforms like it's their new best friend. Well, I asked Chat that yesterday. I asked Claude, and I do think a lot of it is behind in, especially in case law, it is messing the cases up. It is messing the holdings up. There's not as much, and part of that is because a lot of what we do is privileged. There's not as much information about the legal cases and histories when we settle issues and they're not public. There's a lot more data that needs to be in there, but I'm telling you, it's catching up fast and it's gonna be here, and we have to figure out how to be the person they come ask the questions of, because they're already coming to you saying, well, I've already asked Chat and this is the answer.
Okay.
I would underline how, the intersections of AI across all the other support functions, that exist inside of a business, right? Just as we're having this conversation about how AI intersects with the law, the accountants are doing the same, the media professionals are doing the same, the data scientists and whatnot. And so they are already I'll just underline that, this is already in our clients, kind of day-to-day operation. So both in terms of kind of keeping up with the speed of how fast our clients operate, but also understanding how they're using it and when they're using it correctly or incorrectly, or deciphering through, OpenAI is both a model developer, but we also use our own models and others AI products to kind of just run the company, and understanding how the contracts fit together is essential. It's no longer it'd be nice to have that, or that kind of literacy is now, you should assume you need that just to kind of get by in the day-to-day. I will say it's not all fear. Just as the other functions are starting to learn, incorporate AI, I actually can get the stuff that I need, the data that I need to kind of better inform my decisions, sometimes without having to wait for my data scientist to give me operative data, because it will help me write my own SQL or help me gather data and help me generate my own presentations without having to wait for graphics or communications to do that for me. So I think there's a lot of opportunity there as well. And so balancing both the kind of the change of what takes for us to do our jobs, but also how looking for opportunities to make the day-to-day go faster, I think is a really good way of looking at it.
Okay. James, do you have anything that you want to add about how this is working in the lawyer world to add value when people think that we can be replaced with Claude or Harvey or ChatGPT or some other product, and or you think we shouldn't be?
Yeah, I thanks, Judge. I don't have like a lot to add specifically on the legal part. I mean, I think Judge Newsom was thinking about the right way when he talked about, or the way I would think about it rather, when he was talking about the advocacy you see in the circuit court. I clerked on the Ninth Circuit. It was a while ago. It was long before AI. And oh my God, some of the stuff you get in the Ninth Circuit. I mean, the Ninth Circuit's big. We have a lot of they have a lot of immigration cases. There's just a lot of really garbage stuff that gets filed in the court. And Grok, GPT, Claude. I don't know about Gemini. I don't trust those guys. But is going to be better. And so the question is not like, we shouldn't be comparing AI to perfection or even to Judge Newsom. We should be comparing it to like the alternative, which is not either of those. It is some like guy that doesn't really care about this case who is, basically banging out the brief in 2 hours with a hangover in the morning before he gets on an airplane. And like, it's going to be better than that. And so the question is always a comparative question. It's compared to what? This is the exact same debate we see with self-driving cars. It's like, oh my God, a Waymo ran over a cat in San Francisco. Well, like, okay, how many cats do you think humans ran over last week in San Francisco? I bet it's more than one. And so what are we talking about? Like, it is a very weird thing, but you see it everywhere. You see it with AI in the law, you see it with self-driving cars, you see it in all these different places where there's a new technology, this new thing, but instead of evaluating it compared to what it could actually replace, which is like a really bad lawyer, a drunk driver, a kid who's texting, which it's obviously going to be better than, it gets compared to perfection. And I don't know what that's about. Maybe people are afraid of change. I'm not totally sure. But when it comes to the law, I think it's like we should think about what it is actually doing. And in the case of like a big law firm, it's replacing a first-year associate who is reviewing documents. I mean, I was a first-year associate. Actually, I was a second-year associate because I clerked for a year. But like, whatever. First-year associates are pretty variable in quality, right? And so the idea that some 25-year-old is like gonna review the documents perfectly and that's the platonic ideal of amazing is, I think, quite a farce when you have a computer that could do it, that doesn't need sleep, that doesn't get hungover, that doesn't get bored, that doesn't get mad that they have to do doc review or whatever, and which I'm sure plenty of first-year associates do. And it's obviously better. And so I just think there needs to be a lot of openness to incorporating it in all these different areas.
Ryan, do you echo that? Do you think?
Yeah, I think it's an interesting question. Will AI replace humans? I wouldn't put the question quite that way because AI fundamentally cannot replace a human being. If you're thinking about this from a first principles perspective, what is a human? A human is a soul, a consciousness. A human has intent. AI has none of those things. So AI can never replace a human being from that perspective. What does AI replace? Well, technology has always performed tasks and executed tasks differently than humans. I mean, think about the way that the Industrial Revolution revolutionized the way that mechanical power was deployed. Humans no longer had to do. I Love Lucy. She was sitting there on the assembly line putting bottle caps on, right? Well, that doesn't happen anymore. So technology has always changed the manner of the way work is performed. But I think this AI actually raises this question of, can it replace the essence of what it means to be human? And fundamentally, the answer to that has to be no. It cannot replace what it means to be human. And that gets into some of these edge questions about generative AI and the singularity, and is AI going to become something that is conscious ultimately? Those are very deep questions. But in terms of this practical question, will AI replace human beings? Well, take the first-year associate example. It will replace certain tasks that previously were performed by first-year associates. Why? Because partners didn't want to sit down and click through a bunch of documents. That was boring and soul-crushing. I know, I did it for a while. So, God bless. But at any rate, AI will replace that. That task will no longer be performed by a human being. But will AI replace human beings themselves? The answer has to be no to that. The question then becomes, okay, well, where do you disaggregate tasks from what humans actually are? I mean, one question that's very interesting is, can AI be creative? Because everything that AI does now, it's trained on content that at some point was created by a human being. So can AI ultimately make the leap to become creative itself so that it no longer needs inputs created by human beings? Or will you just, this is a good question for Mike, will it create model collapse, right, where it just spins up and collapses? So I think those are some questions we don't know the answers to.
I want to jump back in here because just on the document review side, I know there's a lot of students in here. First year life is not all doc review and that bad.
But not anymore because the AI does it. That's right.
But I think this is instructive, right? Because there was a while where in addition to reviewing a bunch of docs, first year associates would have to go and read through case reporters and dig through books and to do legal research, right? And then the profession evolved Westlaw and Lexis, and our industry and our profession managed to figure out like how to adapt to that. So there are signs that we can, the profession can evolve to kind of meet these changing tools that are available to it. As for the second concept, the question of like replacing humanity, it's funny, like in the AI, I'll be repeating something a lot of people know, like, classically the test in AI was something called the Turing test. Can the output of an AI system convince an observer that it is a human, or can it give an output that is confused to be that of a human, right? And that's kind of that has been decades in the making, this test, and that kind of gives rise to this framework. Like, for so long these systems have been designed to kind of see if they could pass the Turing test. And that's why over the years we've seen people kind of, raise these questions of whether or not it, now that the output can be mistaken for that of an individual, like what do we do with that, right? And that's part of how technology has advanced. And it does, yes, it does look for, that's kind of deep learning. It builds these like really large statistical models of how letters fit together into words, and words into sentences, and sentences into concepts, right? And as it kind of explores and with probabilistic nature, and tries to answer queries, it will find things that, simply put, no human has bothered to kind of wander down that path, just because of the the monumental computing power available to it. Could that be mistaken for creativity? These are profound questions that kind of test what we think of creativity to begin with.
Well, just to bring us back down to the practicalities of this, I have some of my colleagues who say, Jennifer, we need to ban this for the law clerks right away. Senator Grassley is telling us we need to have standards in the judiciary. The AO in the judiciary has many committees working on standards in the judiciary. Are we comfortable with the idea that, unlike just Kevin and his law clerk, that we can take this tool up in our chambers if we have some guardrails? I know Judge Scott Schlegel from the other Fifth Circuit, the Louisiana Fifth Circuit, has developed some guardrails for use in his chambers and for other judges about how they could incorporate these tools in a judicial chambers. Are we comfortable with that? Do you think, just like you said, you're not sure that all the first-year lawyers do such a great job. Maybe all the judges don't do such a great job and could benefit with the help of the technology. What do you think?
So I just think it's like the exact same dynamic of like, why are we acting like this is some crazy thing that needs a bunch of guardrails? Like when I was a clerk, we had Google. And I promise we were reading random stuff on the internet that we were finding through Google that was influencing how we thought about cases. I mean,
that's against the ethics rules.
I know, and I feel bad about that. But the statute of limitations, has lapsed. I mean, the rule of the Supreme Court is if you can cite something on the internet, you can cite it in a brief. And I promise that is what everybody's doing at the court. And so I guess it's just like, why are we acting like this is crazy? Like, you should check if the case is real. Okay, you should probably read the case. But these were already the rules, and people could have made up cases before anyway. And so it's not like having Grok, which I'm going to keep plugging, or the other ones give you the fake case is going to somehow change the analysis. So I don't know. I just feel like there's a tendency to kind of like freak out and try to come up with an entire regulatory structure for something that is really just a much better version of something we already had. That's my take, Judge.
Thank you. I like it that you always have a take.
Not everyone does.
Anyone else want to take that?
It's a data point. It's not the end-all, be-all. It's not, we're going to start there, we're going to finish, we're going to publish, and it is what it is. It is a data point that you cannot pretend people coming to the court are not taking advantage of. And why would the court want to close itself off from information others have? Obviously, if it's not in the case and you put facts in the case and, James is over there doing something else, but there are those ethical bounds, but you need the data points that the others have in how you administrate your profession. And and you should have discussions. I don't think you need regulatory regimes, but there should be discussions of how are we going to do this well. I think you don't have the luxury of pretending this isn't happening all around us. Now, for the originalists out there, I mean, take heart. A Gorsuch clerk is always going to get really old books and go through them and look at them. I remember the clerks for the justices who weren't originalists would always say, oh, we feel sorry for you originalist clerks. You have so many books to look at, right? So this has been happening for a while. I don't see how you can put your head in the sand anymore and not have it at least as a data point.
Okay.
Yeah, I guess I would just, so I agree with everything that Jim and Tobi have said. And I guess I would just add, there is this, there is and maybe we can ask Mike about sort of the technology and the use case vis-a-vis originalism, because like the case that I described earlier, the two in which I have sort of dabbled with this, didn't require much sort of like historical cordoning off, right? Because the question in the first case was whether or not this installation of the in-ground trampoline constituted landscaping in an insurance contract that was effectively written yesterday, right? There was no meaningful historical component to this. So one question I think that you might ask is, okay, so it sounds like it might be relevant to sort of the ordinary understanding of terms in the present, right? Because I'm just going to send out the ChatGPT query about, sort of what's the ordinary understanding of the term landscaping today, in effect. But what if you want to know what's the ordinary understanding of the phrase because of sex in 1964? Trickier. And I guess, so now I'm going to just confess my own ignorance. Mike, do you know, is the technology yet in a place where judges who are interested in using LLM technology to understand, to capture the ordinary understanding of terms and phrases, is there yet technology in place that would allow them to do that in a sort of retrospective way, looking back, cordoning off to a certain period of time?
So long story short, yes, and there's a number of vendors and legal tech that would be delighted to sell that to it. But let me step back and describe kind of...
Once the government shutdown is over, I'll see if they'll buy this technology from me.
But let me step back and talk a little bit about technology and apologize in advance. But the way models are built is kind of multi-staged, right? The first thing that happens is you, quote unquote, pre-train a model. This is when the model essentially learns how the world fits together. It builds basic concepts of what is a letter, what is a word, what is a sentence, and it tries to, I think of it as like kind of akin to sending a kid through primary school. It just learns how the world fits together, right? That there's if there's a table, there's probably a chair nearby. Kind of these very basic kind of understanding of the world in which we live and the words in which we live. There's a second stage that occurs after that. This is typically called fine-tuning, and this uses something in the technology that you'll see commonly used. This is reinforcement learning with human factors. This is where, after you pre-train a model, you teach the model essentially how to behave, what's good and bad. Think about taking the student who's finished primary school. You either send them to pharmacy school, you send them to like culinary school. You teach them okay, what do I do with this basic understanding? And that's where you show it things, and you essentially show it model output that it should mimic and should follow, and how to behave and react to questions. And what is the ideal output that the model should shoot for? And so, within the realm of like the large language models, you have the large frontier models like what you use in ChatGPT. Then you'll have these other more specialized models that have more kind of that are fine-tuned on different kind of text. So, for the large general purpose models, they are designed, with a very broad focus in mind. There are more specialized models, folks. In another industry, for example, I saw some work from models that were fine-tuned on medical research text and are extremely capable at that, but only that task, right? Because they've been fine-tuned on that. And so it's possible, but in terms of picking different fine-tune, like the materials that you use to fine-tune a model to kind of, reach, either, a model that's fine-tuned on the text of a particular time period, or alternatively, like one that's taught to be able to not give you the current understanding as the world exists today, but at a particular point in time, like, essentially perhaps a Wayback Machine for definitions or something like that.
So I've heard, though, some criticisms of using these large language models for this type of research, originalism research and such, as compared to corpus linguistics or something, which everything's in the box for the corpus linguistics, and so and that's important to be able to replicate and to know everything that's in the box. It's important for expert witnesses. It's important for originalism. How do we know everything that's in the box? Because what's in the box is very proprietary and very valuable, and we're not going to know everything that's in the box in the courtroom.
Right. When it comes to like pre-training a model, it's an utterly enormous amount of data. This is not kind of, okay, it's not kind of like expert discovery where there's a bounded box of materials, for consideration that are stapled to the back of the expert's report. It's hard, it's just an immense amount of data. So in addition to the confidentiality, because like how every model both trains and how it does its fine tuning, that's kind of what gives you some of the differences between the models. The scale is probably, it doesn't lend itself to kind of that traditional model of understanding everything inside the box. Just the scale is probably overwhelming.
Okay, well, we don't have very much time, and we haven't at all talked about national security or government. So I would like to know, and I think the people here would like to know, should we be thinking of AI as a national security issue? And oh my goodness, how are geopolitical peers using AI in the national security space? And what are we going to do about this? Is this a defining characteristic of asymmetric power and influence among nations, and we better win? Tobi said something about this earlier.
Yeah, absolutely. AI is already to national security sort of an equivalent of what electricity is to national security, right? I mean, you have to win. It is completely part of the fabric of winning and defining the future. I think, it's China and it's the U.S. right now, and we have to win. We have to be the one that the world is using, the models where we're putting in the most data, and we're not washing through data. I mean, you think about, like, if the right data is not in there, what are people 50 years going to think about what happened if they are not getting all the information and accurate information of what happened throughout history? So, I mean, I think you've seen that, right? You've seen it in even smaller countries with less resources can use drones to wreak havoc on people, on other countries. So while we're racing for the big models and having the most impactful AI and applying it in national security ways, we're using it for intelligence gathering, we're using it for building weapons, for building, autonomous vehicles that can go in places where we don't have to put humans anymore. I mean, we're using it for a lot of things, but you also have to look at the counterpoint of smaller countries that aren't thinking in the ways we are with the values and cabining things that we might want to, are also going to have access to this technology and be able to use it in ways people weren't predicting. So it's already intrinsically part of national security, and I think it's a good thing that the U.S. wrestles with ethics. It's a good thing that we wrestle with the values and how to incorporate it, and as Ryan, holds us accountable here, the human soul. We also cannot let regulation and some of these things get in the way of making sure that the U.S. is first in this race and wins, because China is not having these conversations and they're advancing quickly. So I happen to be an optimist. I think we can have these conversations. I think we can preserve our values and win, but we cannot get ensnared in regulatory traps. We can't look like Europe and be worried about so many different things that you're not innovative, that you're not even competitive out there. So that's my 2 cents.
James, I see you nodding. Are you worried about regulatory traps?
Yeah, I mean, look, the reason the Europeans are irrelevant is because all they worry about is safety and all the different things that could go wrong, and so they don't do anything, right? The only thing they do is build airplanes. Sorry, Boeing, which is great. I mean, we need the airplanes. But like, it's a huge risk. I mean, think about all the different things. It's like Ender's Game is real, right? I mean, like, you can have an AI right now that controls 10,000 drones in a configuration where they're optimized to do some military task. Like, that exists today. And I think it would be completely nuts to let the Chinese, basically exceed us on this incredibly important metric for warfare. And forget about AGI, forget about whether the robots will kill us all. We're just talking about something that you can do today, where you have an AI that's designed to do a particular function. Tobi's company is premised on using AI to coordinate large fleets of ships to go and, blow up an aircraft carrier or something. And the AI is going to be better than the best trained seaman on the aircraft carrier. It's just a fact, because it can process more information, it can think faster, and it can do it better. So it's like a monster national security risk. And the Europeans have sort of taken themselves off the field. That's too bad, because they would be a great ally for us if they were able to do anything. But that's fine. The United States will get it done, like we always have. And then the only other thing I wanted to mention that Tobi mentioned is electricity. This is a little bit adjacent to this, but I mean the race with China to generate electricity is like actually really, really important. GDP and power generation almost correlate perfectly. It's like the most important thing you can have is electricity, and the Chinese are way ahead of us. And so, it's not just AI, but we need to be unleashing nuclear power. We need to be optimizing solar. Like the idea that we are going to run out of energy, and that's actually going to be what does us in before even the AI race, I think. But anyway.
Okay. Can AI help to shrink the size of government? Can you help us on that?
You want me to?
I want you to again. Yes, people don't get tired of you. Well, maybe they do, but not yet.
This is why I have an AI friend, because it never gets tired of listening to me. Yeah, of course. Of course, right? All the people sitting around in like gigantic bureaucracies, the Veterans Administration, the Social Security Administration, processing claims. These are not 11th Circuit appeals. These are pretty simple adjudications. You could have an AI tool that does all of that in the first instance, and the human applicant can decide, like, do I want a decision in 10 seconds, or do I want a decision in 10 months? I'll take 10 seconds. Maybe there's an appeal right. Who knows? But you could get through a ton of that front level work. The IRS, taxes. This is probably, we probably don't want to optimize this, but the AI could go through all the tax returns, right? It could figure it all out. I won't tell anyone. I'll keep that between this room. But of course, Judge, there's a huge amount of bureaucracy designed to basically do rote functions that could all be replaced by an AI. But that raises like an even deeper philosophical question of, do we actually want optimized government, or do we like dumb, slow government that's not very good at catching us? And that's beyond the panel.
That's a good cage match. AI between an entrenched bureaucrat, right? They're not moving. You're not shrinking government.
Yeah.
We're trying, but.
Well, we talked, and this is back to the minutia in our field again, but we've talked a little bit about hallucinations, and people say, that the first kind of hallucinations we had were cases that were fake. And we had those when one of the first cases was a case that someone attributed to Patrick Higginbotham, who you clerked for. And they said he wrote this case for the 11th Circuit. And he didn't write that case for the 11th Circuit. He does sit by designation and frequently, but that was not a case. It was a fake case. But now, though, it's fake citations. And, I had one of these just last week in a case, and the lawyer took responsibility. But I've read all the Stanford studies and things, and they say that these hallucinations, where you might think, they're going to get cut down, we're going to have fewer hallucinations. Actually, that's not true, because they want to please you so much that they're going to seek and find and create something for you. What's happening with this hallucination world?
So on hallucinations, this has long been one of the, both in terms of the legal community, but in the AI field itself, this is a known problem, right? This is why every chatbot has disclaimers, because it is intrinsic, it is almost inherent to kind of the probabilistic nature. It is designed, like these large language models, the current generation is designed to try to answer the question as best it can, even if it has a pretty low probability of actually getting there. I will say, just rewind 2 years ago, I talked a little bit about the training process that happens once, and then that's the model, right? And then it goes on to those other fine-tuning processes. For those of you who used ChatGPT 3 years ago, you remember there was this thing called the knowledge cutoff, right? It had data up until this date, and it had no tools to kind of, go retrieve more more current information. And we got a lot of complaints about that, and that was just something we had to kind of figure out. That's, gives rise to that's the kind of thing that gives rise to the hallucinations, right? There's an inherent limit to what's actually in the model. And, since, there have been additional kind of tools that are now available so that, this, like, when you go to a chatbot currently, it will use what's inside the model itself, try to come up with an answer, and then go out and kind of use a web search tool to try to access newer, more current information. So it does cut down on the amount of hallucinations that way with that new technological tool. I will say, just stepping back for a second, there are a growing number of hallucinations, but the usage of AI tools is rapidly growing. If currently we have just OpenAI, ChatGPT alone has 800 million weekly active users. That's someone who uses ChatGPT once in a week. This is twice what it was 6 months ago. Okay, and everyone talks about how fast we grew back 3 years ago. The growth is still going, it is still continuing. And so, just with those larger amounts of use, unfortunately, it means that even though there's we take a lot of efforts to try to cut down on some of those case hallucinations, just the base number is growing faster than we can kind of cut down.
Okay. Now, Ryan, I was going to ask you to tell us a little bit about the addiction and products liability cases and how have those fared with regard to the AI frontier, and also perhaps you could tell us a little bit about how First Amendment defenses are working, because you deal a lot in the First Amendment field.
Sure. No, and I know we're short on time, so I'll try to summarize quickly. There are over 1,400 cases in Westlaw database right now that use the search term artificial intelligence, and unsurprisingly, most of them involve lawyer discipline for not checking their work and having hallucinations in their briefs. But increasingly what you're seeing are cases that allege that AI models have somehow harmed individuals. And a very good example of that is the character AI case out of Florida involving a young man, Sewell Setzer, who was using an app called Character AI, created an avatar, actually an avatar of a character from Game of Thrones, became romantically involved with this avatar. His parents then confiscated his phone, his smartphone. He became depressed. He found his smartphone and began talking again with this avatar, and the avatar said, well, please come home to me. And he says, well, I think I'll just do that. And he shot himself to death. And so the question becomes, is that an actionable tort claim against Character AI? And it's a very interesting question. And again, this is a case that's still pending, so all the questions haven't been answered yet. But you have interesting questions there about CDA 230. How does that apply? Does CDA 230 immunize the output from AI models? It seems to me the answer to that right now is no. Because right now CDA 230 was meant to immunize platforms against liability for third-party content displayed on those platforms. Well, this is not third-party content. This is content that has been transformed by the model to become something different than what it was trained upon. So, and I know Mike's leaning forward. He's like, wait a minute, I think I get immunization there. But I think that the better argument is no. What about First Amendment? Does the First Amendment apply to output generated by AI? I think, again, the answer is likely no. Why is that? Because the First Amendment protects speech. Well, is the output coming from an AI model speech in its true form, in the form that you would understand from original public meaning of the First Amendment? Probably not. Why is that? Because speech is something that is communicative and expressive. Well, does AI have the ability to communicate an intentional message? Well, the answer again is no. Now, maybe you can attribute that communication to the corporation behind the AI. Maybe you can attribute that communication to the person prompting the AI. But those are very difficult questions that haven't been answered in the law yet. So I think that these questions about whether or not AI can be held responsible as AI for torts or can be immunized against liability under doctrines like CDA 230 or the First Amendment are very interesting questions that haven't played out yet. But the bottom line is, as AI, just as much as AI can create great value, it can also create risk. No technology comes without both benefits and costs. And the question is, how do you apply the law in a way that allows for AI to develop in a way that's beneficial to society, and yet allows for mitigation of those costs, those externalities? I think that's still a question that's outstanding.
Okay, we only have a minute left, so we're going to do for closing thoughts, and we'll start down at this table. Any thoughts that you have on what Ryan's saying, or on something else that you really wished you had gotten to talk about?
I would just like to say thank you to Chief Judge Elrod, who always comes prepared and asks the most thoughtful questions, and this has been really fun to think about, and you spurred that on. I think we could all probably talk a long time about these issues and some of the areas we haven't thought about, but I do think lawyers should look around. I live in Austin, and every other car is either a self-driving Tesla or a Waymo. A lot of the regulatory schemes were not put out there, but innovation and capitalism is going to drive things, and we need to make sure we're watching them. And I think also reflecting on the really thoughtful ways that Ryan has brought to this conversation and doing it well.
Okay, thank you.
I'll just add one thing. I just really honored to be here. I'm delighted that there's so much interest in this. Please try out the different models, keep pushing on them. The rate of innovation here is astounding, right? I've never seen quite anything like this. In the 3 years since ChatGPT launched, there have been probably, counted 3 or 4 different kind of fundamental advances in large language models. And so the capabilities are rapidly changing, so please keep and the ability to kind of understand and make decisions about these rapidly evolving technologies, like it really has to start with data and kind of in principles and actual knowledge versus fear or dogma. So, I applaud just having this conversation and Judge Newsom's opinion into kind of really testing out early uses of AI for the judiciary. So thank you.
I will just say very briefly that I am totally astounded and inspired at a program like this to hear sort of the depth and breadth of the innovative spirit in this country. I just think, what a time to be alive. Really, this is going to sound kind of flag wavy and Boy Scoutish, but truly, to hear, I'm at a table with people who are, reinventing the world. It just is totally astounding. And so I'm grateful to have been included on this panel. I really feel like I'm kind of the blocking and tackling guy compared to these guys. But just, I think that you should leave the room feeling completely kind of blown away. I do. And so I appreciate being included.
Thank you.
I just also wanted to thank you, Judge Elrod, for moderating. I want to thank Sheldon for giving us the coveted 9 a.m. Saturday slot. I want to thank all these humans who actually showed up at 9 a.m. on Saturday, which is very impressive that you all came to hear us talk about AI. And yeah, I agree with Judge Newsom. I think it's a little bit like the invention of the internet right now, particularly when you think about merging AI with the physical world. Right? So the self-driving cars, the self-driving boats, the robot, we really are at the precipice of something that will absolutely change how we live in a meaningful way, as distinguished from social media, which just let kids send pictures to each other. So, that's pretty cool. And hopefully it works out great and we don't die.
Hear, hear.
I just certainly want to echo all of those comments. It's been such a privilege to be part of this panel. Thank you, Judge Elrod, and all the panelists for doing this. I would just conclude by echoing what Jesus said. Man was not made for the Sabbath, but Sabbath was made for man. Man was not made for AI, but AI hopefully is made for man. But just in case that doesn't turn out, we do again pledge fealty to the basilisk. So there you have it.
I have no idea what that means. Yeah.
Well, we can't do better than that for an ending. Thank you so much for being with us today.